Before we begin, remember that this video is for educational purposes only and isn't legal advice. Always consult a qualified attorney for your specific situation. This is the kind of legal knowledge that can save you from expensive mistakes. You spent months picking the perfect name and designing a killer logo, but if you haven't protected them legally, a competitor could force you to rebrand overnight. I'm going to show you how to lock down your brand assets without wasting thousands on unnecessary legal fees. Alright, let's start with the real-world problem. Many entrepreneurs think registering a business name with the state is the same as owning it. It's not. A doing business as name only lets the state know who is running the shop. It doesn't rethink someone in the next state from using the same name. A trademark, however, gives you exclusive rights to that name nationwide within your industry. Think of a DBA as a name tag and a trademark as a deed to a property. In the US, you actually get some limited protection just by using your logo in public, which are called common law rights. However, these are incredibly hard to defend in court and only cover the specific geographic area where you operate. If you want to expand or sell online, common law rights usually aren't enough to rethink a copycat. Not every name can be protected. The law looks at how distinctive your brand is. Fanciful names like Kodaks are the strongest, while descriptive names like cold ice cream are almost impossible to trademark. If your name just describes what you sell, you might be wasting your money trying to register it. Before you file anything, you need to make sure you aren't accidentally stealing someone else's idea. This is where most people get into legal trouble. The USPTO has a search tool called TESS where you can look up existing trademarks. You aren't just looking for an exact match, you're looking for anything confusingly similar. If your name is Cats and someone else has cats in the same industry, your application will likely be rejected. Trademarks are organized into 45 different classes or categories. This is why Delta can be both an airline and a faucet company without a legal battle. When you apply, you may want to choose the specific classes that fit your business, and adding more classes increases your filing costs. A USPTO search isn't enough because of those common law rights we mentioned earlier. You should also check social media handles, domain names, and state-level business registries. If a competitor is already using the name on Instagram, even without a trademark, they could still block your progress later. Quick reminder, this is educational content only, not legal advice. Laws vary by jurisdiction, so always check with a local attorney. Once you're sure the coast is clear, it's time to actually file the paperwork. Here's what the timeline and the bill look like. There are two main ways to file online, TEAS Plus and TEAS Standard. TEAS Plus is cheaper, usually around $250 per class, but it requires you to pick from a pre-approved list of business descriptions. Standard is more expensive, but gives you the freedom to write your own description of what you do. The government won't just take your word for it. You have to provide a specimen or proof that you're actually using the logo in commerce. This could be a photo of your product packaging or a screenshot of your website's checkout page. A simple business card usually isn't enough for a goods-based trademark. If you haven't launched your business yet but want to reserve the name, you can file an intent to use application. This protects your spot in line while you build your brand. However, it does involve extra paperwork and fees later on once you actually start selling. Getting the trademark is just the beginning. If you don't maintain it, you lose it. Watch out for these common pitfalls. After you file, an examining attorney will review your application. If they find a problem, they issue an office action. Don't panic. Some are just simple fixes like clarifying a description, but others require a legal argument. You usually have 3 to 6 months to respond, or your application dies. The USPTO doesn't police your trademark for you. It's your job to make sure no one else starts using a similar logo. If you let others use it without a fight, your trademark can become genericized and you could lose your legal rights entirely. Trademarks don't last forever without effort. Between the 5th and 6th year after registration, you may want to file a Section 8 declaration to prove you're still using the mark. If you miss this window, your trademark will be cancelled and someone else can snatch it up. DIY is great for saving money, but sometimes a mistake can cost you your entire brand identity. Here's when you should rethink and call a lawyer. If the USPTO refuses your mark because it's too descriptive or confusingly similar to a big brand, that's a substantive refusal. These are hard to beat without a lawyer who knows case law. If you're facing a multi-billion-dollar company's legal team, don't try to handle it alone. A US trademark only protects you in the United States. If you plan to sell in Europe, China, or Canada, you need to file through the Madrid Protocol or individual foreign offices. This gets complicated very quickly because every country has different rules. If you find someone using your logo, your first instinct might be to sue, but a poorly worded cease and desist letter can actually lead to the other person suing you first to prove they aren't infringing. A lawyer can help you send a letter that gets results without starting a legal firestorm. That's the practical version of how to protect your brand. The big idea is to search thoroughly before you spend, understand that a trademark is an ongoing responsibility, and know when a professional's advice is cheaper than a rebrand. Start with a TESSS search today to see where you stand. If this guide helped you understand the process, like and subscribe to Lawful Finder. We're here to help you navigate the legal side of business so you can focus on growing your brand with confidence. If this helped, like the video and share it with someone who needs it. Thanks for watching. Remember, this is educational only and not legal advice. Always consult a qualified attorney before making legal decisions. Subscribe for more plain English legal explainers.